Wilbot.
May it please your lordships, I was going to recommence just by making a couple of short points more about City of Edinburgh, given that my reference to it was not entirely uncontroversial. I want to just go back there and deal with two more references, if I may. The first...
What are we looking at?
City of Edinburgh, my lord. This is in the...
Page 1007 we were on,
Indeed,
tab 5.
I wish to go back to page 997.
Righty-ho. Yep.
Just to note, D to F, that Lord Brown-Wilkinson, Lord Mackay and Lord Stane were in agreement with Lord Clyde. And then Lord Hope of Craighead also gave a full judgment. If I can ask your lordships to go over the page to 998.
Yes.
B down to E, Lord Hope makes, if I may say so, essentially the same point about the status of the plan, and in the
Same point assumed. And what they're all saying, which was common ground, was that the new section gives greater status to the
Yes.
well, they say more than that, my
plan,
lord.
but it may get outdated, and so you have to have regard to other.
Indeed, and specifically, what Lord Hope identifies at D, in the sentence beginning but some of its provisions may become outdated as national policies change, or circumstances may have occurred which show they're no longer relevant.
Yeah.
And makes the very point that I say disposes of the idea that in some way it is in any way constitutionally or otherwise illegitimate for national policy to be an other material consideration which reduces the weight that attaches to development.
That. What all that's being said to you is that you can't, the national policy can't say that something's outdated if it isn't.
Yeah, exactly.
Well, my lord,
There's nothing in here which suggests that you can.
well, my lord, the concept of outdated isn't simply a matter of chronology. And I want to come on to this and develop this more fully by reference to the framework, but just to encapsulate the point that I'll come back to. The framework adopts a specific and consistent approach to what is an up-to-date plan and what a plan should achieve. If that plan is no longer achieving that, or doesn't achieve it, to regard it as up-to-date.
But in respect of those policies which are not achieving it, of course.
Indeed.
Your housing policies are not up to date insofar as they're not achieving the relevant amount of housing.
Indeed.
But the Greenbelt policies are just as up to date as they ever were.
Well, my lord, save for this, that those Greenbelt policies are framed in a context where the plan anticipates that by having the boundaries of Greenbelt or having the boundaries of countryside or other restrictive policies where they are, the plan will provide for the appropriate supply of housing. If it turns out in practice that it does not do that, that the balance struck by the plan maker at the time the plan was put into effect, in practice is not borne out by the reality. It doesn't deliver what was anticipated. At that stage, it is an entirely lawful and proper thing for national policy to do, to say that that policy should not be considered up to date. That is an other material consideration.
I hear what you say.
And my lord, your lordship asked me to look at the authority of Loop.
Well, no, I didn't. I just asked you where it was.
Indeed.
I've had a look at it, and it says exactly the same thing.
Indeed.
What it does is to effectively give effect to the then equivalent of NPPF, which was PPG1, which makes exactly the same point.
And it draws a distinction between policy, saying what weight ought to be applied to a development plan, and Section 38.6 itself. Now, my lord, coming back to the submissions that I was making about this, which is, this is not a question of whether or not it is legitimate for paragraph 49 to treat policies, to deem policies as out of date, because that arises under either interpretation. Policies in a development plan are considered out of date whether they are under the narrow interpretation or not. Such policies are not and could not be put to one side or disapplied. That couldn't be the legal effect. The NPPF itself doesn't dictate the weight that should apply to a relevant policy for the supply of housing that is considered out of date. It may still attract sufficient weight, and often does, to justify the refusal of planning permission. And can I ask your lordships in that context, please, to take up the Secretary of State's written case and to turn to paragraph 56. In the core volume, that is on page 183. And what we do in paragraph 56 is seek to draw together, for the court's benefit, factors which decisions of the planning court have indicated may well be relevant to the amount of weight to give to policies deemed to be out of date under paragraph 49. So they include the particular or specific purpose of the restrictive policy, the rationale and evidence base for the policy, whether the objectives of the policy continue to be sound, extent of the shortfall, nature of the shortfall, reasons for or causes of the shortfall, action being taken by the planning authority to address the shortfall, how likely it is to be overcome, whether it's going to be addressed with an appropriate timescale by other means, and the housing land supply position in different parts of the authority's area. That gives a flavour of what, in the short time since this issue started to be litigated, the court has recognised as the factors which may well mean that significant weight is given to those policies, recognising, in the case of, for example, a recently adopted plan, whether the evidence, the rationale and evidence base for the policy continue to be sound. It may be in those circumstances that it makes little difference to the weight that is attached, that it is deemed to be out of date. That doesn't tell you what weight should be applied to it. It merely indicates to the decision maker that as a material consideration, the decision maker must ask the question, what weight do I attach to this policy in the circumstances in which it has come to be considered out of date by the framework? It is no more, but no less than that. There is nothing unusual about national policy giving rise to that consideration. It's the same principle as applies where a new national policy renders existing policy in a development plan out of date. So to conclude on this point, the policy matters, including paragraph 49, arising from the application of the framework, are relevant material considerations, but they neither displace nor do they erode the statutory presumption in favour of the development plan, which continues to apply. And my lords, I then turn to some main points of context from the framework itself. And the first of those points is that it is, we say, important to understand the overall approach in the framework to the provision of housing and the sustainability balance, and how there is a joined-up approach through plan-making and decision-taking. This is a matter we deal with in our case at paragraphs 17 to 26. And the starting point, my lord, is that the presumption in favour in paragraph 14 applies both to plan-making and decision-taking, in a consistent and complementary way. And just for your lordship's note, we make reference in our written case to the way this is summarised in the Barker Mill case, that's tab 15 of volume 2A, at paragraphs 118 to 120. And I commend that in due course as a clear and succinct explanation of this point by Mr. Justice Holgate. And if one turns to the framework and to paragraph 14, I'd ask your lordships to go then to, it's an appendix part 2, page 215, to look at the introductory words to paragraph 14. At the heart of the National Planning Policy Framework is a presumption in favour of sustainable development, which should be seen as a golden thread running through both plan making and decision taking. And that consistent and complementary approach is taken to judging the sustainability of planned housing, having regard to the balance of the three dimensions of sustainability through both of those processes. And what the concept of sustainable development in the framework is seeking to secure, of course, is the attainment of a proper balance between different factors which can pull in different directions. And can I just, your Lordships may find it of use to go to one authority in this context, which is in volume 2A, tab 17, and this is, it's another Cheshire East case. And this is a decision of Mr. Justice Jay, and the part I want just to refer your Lordships to, which we refer to in our case, is on page 1305, paragraphs 19 to 21, which again clearly and succinctly explain the role of paragraph 14 in guiding the trade-off, the balance between those competing desiderata, as they're referred to in paragraph 19. As paragraph 20 explains, in the absence of paragraph 14, decision makers will be unable to decide how tensions should be reconciled. And then paragraph 21 explains the nature of what was referred to earlier as the tilted balance, and one sees the phrase, the balance is weighted, loaded, or tilted in favour of the proposal. This is one of a number of references where the authorities refer to tilted, but my Lords, I commend this as a neat encapsulation of its role within the system. And, my Lords, as I've said, and as we've said in our case, paragraphs 34 and 35, the development plan must set a housing figure which reflects that balance struck using the specific approach in paragraph 14. And that must then be delivered, including maintaining a 5-year housing land supply. And as your Lordships will have noted from paragraph 27 of the Court of Appeal's judgment, underlying all the government policies for housing development is, as they put it, the basic imperative of delivery. And if I give your Lordships references to where that's spelt out in the framework, it's paragraphs 47, 49, 50, 150, 156 and 182. And if in practice, as I indicated before the luncheon adjournment, if a plan is going off course in practice and failing to deliver that supply of housing that emerged from the striking of that balance, then it is entirely legitimate for national policy to make provision to seek to correct it. And that sets the context for paragraph 49, considering relevant policies for the supply of housing as being out of date where that is not achieved. Because in those circumstances, the sustainable balance struck using the presumption in favour of sustainable development through paragraph 14 has gone out of kilter. In practice, if one looks to the framework, can I just direct your Lordship's attention back to the test of soundness? This is on page 254 of using the internal pagination in Appendix Part 2, paragraph 182. And one can see under the tests there, the third test, effective, the plan should be deliverable over its period, and then consistent with national policy, the plan should enable the delivery of sustainable development in accordance with the policies in the framework. So in those circumstances, the plan is not achieving that thing which led to it being found to be sound and hence has become inconsistent with national policy. So what paragraph 49 seeks to do is to deem those policies which combine to strike that balance and to provide that supply as being out of date in order to reflect and correct that unsustainable state of affairs. And that triggers the application of the Section 14 approach for the purposes of decision-making, which applies a balance, your Lordship sort of noticed, using the same tests as are applied in the plan-making process to arrive at the housing requirement in the first place. That's the first point I make about the NPPF context. The second point is that the particular context for paragraph 49 is the clear objective in paragraph 47 to boost significantly the supply of housing and the emphasis on delivery. And paragraph 49 must be construed consistently with that clear objective. And the reference which my learned friend Mr. Kingston focused upon in paragraph 182 of meeting need where it's reasonable to do so and consistent with achieving sustainable development can't be read in isolation from paragraph 14, which is at the heart of the whole framework, and how plan making is to be achieved consistently with the presumption in favour of sustainable development. Well, the third point I wish to address in this context is the concept of radical change. And in addition to endorsing what my learned friend Mr. Lockhart Mummery said about Gallagher, I would just like the opportunity to direct your Lordship's attention to a couple of other references in this context. This is in volume 1 of the authorities bundle at tab 8. And the references to which I wish to draw attention start on page 1060 under the heading Arguments and Conclusion, paragraph 14. 14. And what is said there is, I accept that there are aspects of the NPPF which reflect earlier planning policy, but there are also significant changes. They include the requirement in Para 47 to boost housing supply significantly, formulation in Para 47 to ensure that their local plan meets the full objectively assessed needs, emphasis added, and the treatment of soundness in the framework, paragraph 182. And in paragraph 15, the court then sets out paragraphs 96 and 98 of the judgment below. And if one turns over the page to the top of 1061, there is then the reference in the judgment below to major policy changes. And in the second sentence, as I have emphasised, in terms of housing strategy, unlike its predecessor, which required a balancing exercise involving all material considerations, including need, demand, and relevant policy factors, the NPPF requires plan makers to focus on full objectively assessed need for housing and to meet that need unless, and only to the extent that, other policy factors within the framework dictate otherwise, identifies that also requires a balancing exercise, but then says that is a very different exercise from that required pre the framework. And that echoes...
I mean, that's got nothing to do with what we're concerned with. I mean, the radical change of policy was to incorporate the objectively assessed needs and to say that the plan's got to achieve that.
Well, my Lord, no, if I may say so, with respect.
That's what Higginbottom's saying. I don't
Well,
know
with it is, if I may say so, if one goes down to paragraph 16 to see what was said about that passage that I've just read out to your Lordships, that reasoning seems to me to be entirely correct. And then 5 lines down, the NPPF indeed effected a radical change. It consisted, i.e. the radical change, in the two-step approach
paragraph 47.
Yeah.
Yeah, what's so what? It's got nothing to do with what we're dealing with, which is paragraph 49 and how that ties in with paragraph 14.
Well, the radical change, if I may say so, goes to paragraph 14, and paragraph 14 is engaged by paragraph 49. So the radical change, which is
But you're
consistent...
talking about a radical change in paragraph 47, which is the new idea that your plan has got to meet the assessed needs. And then on top of that, you have the 5-year presumption, which wasn't a radical change, that was old hat.
But the second step is the paragraph 14 presumption in favour of sustainable development, which means you meet those needs unless one of the two caveats
The plan
applies.
is deemed out of date if you don't meet.
Indeed. Well, my lord, your
It
lordship has
doesn't mean that green belt policy is out of date. It's a very short point, and either it's right or wrong, but none of what you're saying seems to impinge on that.
Well, my lord, I submit that in order to interpret paragraph 49 and its breadth, one needs to understand the way in which the MPPF adopts a consistent approach across the two, for the reasons I've said. My lord, the next point I want to deal with is why the narrow interpretation is, as the Court of Appeal held, plainly wrong. And can I ask your lordship, first of all, to deal with, to look at the appellant's case, their written case.
Which page?
Paragraphs 20 to 21.
Right.
Lordship, this is page 131
Thank you.
in the core bundle. And we address this in our written case, so I'll deal with it briefly. But what is...
Where is it in your written case?
In our written case, my lord, it is, bear with me, page 191 of the bundle, paragraphs 89 and to 91. And the short point we make here, which I emphasise here because it goes, I say, to the heart of the question of what the words literally mean, is that what paragraphs 20 and 21 are doing, and one can see it in the first sentence of paragraph 20, is that they take out the words, the supply of. They take out the crucial words that form the subject matter of the policy. And that fundamentally changes the meaning of the phrase by taking out the very concept
See the point.
that it's dealing with.
Yep.
And so one can't artificially constrain it and then add the words back in to artificially constrain it yet further. And that is important because the only dispute, as I discern it from the written cases, as to the literal meaning concerns the word for. All of the other words...
2 days arguing about the word for.
Oh, my lord, but actually, my lord, if one looks at the way in which the appellants put their case, the only word where there is a difference is for. And look at the bottom of paragraph 20, 4 lines up. It is clear that of the 3 meanings on offer, the correct meaning is in respect of.
Yes.
That is the only alternative literal interpretation of the words that is offered. And my point, my lord, and we make it in our written case, is that the same answer would apply whichever of those literal interpretations you took. Policies in respect of the supply of housing, because of the concept of how the supply of housing is formed, would embrace all of those which are embraced by the wider interpretation. And we make those points in our written case at paragraphs 76 and 77 on page 188. And thus, the appellant's literal interpretation would be at odds with the narrow approach if you didn't do that artificial editing exercise. It would be at odds with the narrow approach, I should say, if it were not for the artificial approach that they've adopted in 2021. Policies in respect of the supply of housing would embrace the same concept as policies affecting the supply of housing. Was my next point is as to the absurdity, as we put it, of the practical effect of the narrow approach. We say that is inescapable. The obvious purpose of paragraph 49 in the context of the framework simply cannot be reconciled with the implications of the narrow approach. And your lordships have in the authorities bundle at tab 13, I just ask your lordships to look at what Mr. Justice Ousley said about this at paragraphs 46 and 47, which are on pages 1183 to 1184.
Yeah.
Paragraph 46, it said, it's either very narrow phraseology and specific, confining itself simply to policies which deal with numbers and distribution of housing, ignoring any other policies dealing generally with the location of housing, of development or areas of environmental restriction, or alternatively, it requires a broader approach which examines the degree to which a particular policy generally affects housing numbers, distribution, location in a significant manner. In my judgment, he continues, the language of the policy cannot sensibly be given a very narrow meaning. This would mean that policies for the provision of housing which were regarded as out of date nonetheless would be given weight, indirectly but effectively, through the operation of their counterpart provisions in policies restrictive of where development should go. And it makes the point that I've made earlier to your lordships, that they're the obvious counterparts.
But I don't think you're signing up fully to that, because you're not saying that the policy that's out of date shouldn't get any weight.
The weight, my lord, is, as I've indicated, clearly a matter for the decision maker. It's not dictated. As I understand the reference there.
It's not nonsense. We say, I mean, what one watches through these cases is this idea developing that somehow you have a policy which you have to disregard because it's out of date, and therefore you have to disregard it. Mr. Justice Lyndham comes along then and says, well, actually, you don't have to do that. That's because at the end of the day, it's all a question of weight. And so he sort of softens the effect of that, and that's he did in the Crane case. And in effect, that's what he's picked up in the Court of Appeal now. So in a way, that it softens the edges of the whole thing, because even an out-of-date policy doesn't have to be given, either can be given weight or not given weight, depending on what the inspector thinks of it.
Well, I'd
so
go
the point that Mr. Justice Ousley is making, which was valid at the time, has actually been overtaken by events. And
the point about weight has, but the general understanding of what happens, the absurd effect of what happens if you deem to be out of date those which
give weight to it anyway. Why does it matter?
Because if you are treating, what's the point of a paragraph 49 exercise, deeming it out of date, if those policies that you are therefore raising for the question of what weight do I attach to them in the circumstances are those which positively provide for housing?
But I mean, equally, what's the point of deeming your Greenbelt policy to be out of date if it still applies with full force?
Well, it doesn't apply with full force. Mr. Justice Ousley's point is subject to that comment about weight. It remains valid, because if one construes the settlement boundaries and the Greenbelt boundaries as the counterpart of the housing allocations, and the housing allocations are inadequate, that calls into question those boundaries.
And those policies...
That's the essence of the point he's making there.
Indeed, my lord. And those policies, including Greenbelt policies, are caught as being out of date, but that doesn't tell you what weight should attach to them.
No.
It also, and importantly, with Greenbelt, there are specific policies in the framework which, because of the effect of paragraph 9, if, for example, you can't demonstrate very special circumstances in the Greenbelt to justify your development, then the presumption does not apply. So there are particular policies. Greenbelt as an example, one could say the same of areas of outstanding natural beauty, heritage interests, various things which are being canvassed. They are all still subject to the specific tests, familiar tests, and the rest of the framework. If those tests are not satisfied, the presumption doesn't apply. They are different in their nature, therefore, and different in their treatment, but it's still nevertheless appropriate to consider, well, what weight do I attach to them in circumstances where there is not an adequate 5-year housing land supply? Lord, I hope your lordship's got the gist of our case on that.
I think we got that a long time ago, thank you very much.
I want to deal with the concept of extrinsic documents. I should emphasise that our
Sorry,
position...
which extrinsic
The
documents?
extrinsic documents, those which are not part of the MPPF itself,
What do you mean, the Minister's statement? of
indeed,
Parliament?
matters
But you're
of that
not
sort.
disowning what the Minister said in Parliament, are you?
No, my Lord, this is why I want to make our position absolutely clear. Our objection to these documents is not based on anything that they say. Because the points that are relied upon in terms of this is not intended to change the statutory presumption in the plan and so forth, are on the face of the MPPF.
I mean, there's nothing that he said which isn't in the
Exactly.
MPPF. So
But our point is a point of principle that particularly in this court, to endorse an approach to interpreting planning policy documents where it is legitimate to go back through the gestation of those documents, to engage in forensic archaeology, unless there is a very specific need, an exceptional justification for doing so, would be a very dangerous precedent to set.
No one's suggesting that. I mean, the case which he referred to, the immigration case, was one where there was a specific part of the thing which was ambiguous. And all Lord Justice Ricks said that when you've got something with ambiguous, unfortunately, you may need to look at extrinsic material to reconcile it. But he said that's a very unfortunate thing to have to do. And so, obviously, we don't want to do it.
Well, my Lord,
the ambiguity here is over the phrase for, if there is any ambiguity about it.
But there are...
And nothing said in Parliament helps one on that.
Well, my Lord, if I may say so, that last point is a rather important point which I was going to make. There's a distinction, there are many distinctions between this case and the immigration case that was referred to, not just in terms of the legal context, but the specific context in that case was a word which could have two distinctly different and crucially distinct meanings in that case. And the context, without going to those extrinsic documents, didn't tell you which one they should bear. And the particular statement that was referred to included a clarification of which one was right. And it was only because in order to go...
You're agreeing with what I put to you.
Well, indeed, but my point was, the way we've put it in our written case is, and we choose our words carefully, and it might be worth just taking this up, my lords. It's at the start of our written case in paragraph 6 and 7. So 171 and 172. What we say in paragraph 6, in the third line from the bottom, in the context of what's said in Tesco and Dundee about the purpose of policy, it should mean that normally, the context in which policy falls to be read would include the policy document itself, but no other documents. We have identified, and explaining why we would use the word normally in paragraph 7, particular examples of where exceptionally it is appropriate to look at exceptional, to look at other documents. And the immigration case is simply an example of where on the particular factual legal circumstances of that case, it was exceptionally appropriate to do that. But the court made very clear in that case how undesirable it was and how they sympathised with those who'd have to deal with the consequences of that. And my lords will have noted that when Mr. Kingston was dealing with this matter, he accepted that it would be entirely inappropriate and undesirable to do that for a development planning policy. And exactly the same considerations arise in respect of national policy in terms of those who are meant to be using it, its purpose, its objective, and the undesirability of sending people off on some sort of chase back through the documents.
But I mean, you must accept that. I mean, you're pushing at a very open door as far as I'm concerned, I don't know about my colleagues. But what we've got to is the fact that instead of taking a statement by the Minister, they're taking a raft of decisions of High Court judges, which Mr. Hopkins was. I mean, and that's terribly unfortunate.
It is, my lord, and one of the...
Given that the whole purpose of your department, a commendable purpose, was to try and simplify and clarify.
Yes.
I mean, what can we do about that to try and stop these policies becoming a sort of hunting ground for lawyers in the High Court.
Well, my lord, that, if I may say so, is precisely what the Court of Appeal achieved by emphasising the fact that this is ultimately a matter of planning judgment as to the effect of policies in judging whether or not they are relevant policies to supply
You
housing.
say that the Court of Appeal approach should now put a stop to that, or
Absolutely.
nothing will ever entirely put a stop to it, let's face it, but
It makes it much harder to challenge and much harder to second-guess planners who are trying to interpret and apply these policies if the scope of 49 ultimately requires the judgment of an expert decision-maker as to its effect, as opposed to legal submissions by lawyers as to its categorisation in circumstances where, as you've seen from the policies we have before us here, that is plainly not an exercise.
That was why I was asking you about the guidance and how planning inspectors deal with it. I mean, it may be a bit like what the position we had with specialist tribunals, that we've tended to say is that where you've got issues which come very much within the expertise of a specialist tribunal, the courts of law, they obviously have an important role, should be cautious. I don't know whether you would say the same about decisions of planning inspectors.
Well, indeed, and the courts have consistently emphasised that distinction, that where it comes to the expert planning judgment of inspectors and also the judgments that are made by local planning authorities on judicial review, that is very much the emphasis. That is a planning judgment.
Yes, so where one got a phrase like policies for the supply of housing, I might have thought that's something which one could leave the inspectors to get on with.
Which is exactly what the Court of Appeal says we can do, and ought to have precisely the effect that is hopeful, that we won't all have to cart around lots of decisions which are, as indicated, changing on a regular basis. The Court of Appeal's approach should put a stop to that. So look, I don't intend to say anything more.
Against that, it must be right that you can't have one planning inspector saying it has the narrow meaning and therefore I reach the following conclusion, another one saying it's got the wide meaning and therefore I reach this conclusion.
Well, that is why the Court of Appeal said it has the wide meaning.
No, well, it isn't why they said why it had to have why they laid down it had to have a particular meaning.
Yes. Well, I said loose use of language that's why they said, but that's the
why
effect
they were
of
called
what
on to decide the point. Yeah.
Yes. And that means that then, in terms of individual inspectors, they will have regard to each other's decisions.
well, your point is that once we've decided whether it's the wide or the narrow meaning, that'll be it.
But if it's the wider meaning, yes. If it's the narrow meaning, then I'm afraid that the categorisation then becomes a matter of law, that's my issue 2 point. And that, I'm afraid, will open the floodgates in the way that the Court of Appeal plainly does not. Because then every time you're looking at policies of the sort we've been looking at over the last 2 days, lawyers have to decide, I
can see that anything that affects housing leaves less room for argument than a narrow meaning. That's your point. Yes. Once it can be shown to affect housing, end of...
It's a matter of judgment. And, my lord, so far as the intermediate approach is concerned, which is, as we've set out in our written case, we've set out fairly full submissions on this in response to what are very brief written submissions on behalf of the appellants. And the appellants have said nothing more in oral submissions on this matter. And so I don't want to simply repeat what we've said in our written case. Nothing has been added in oral submissions. There's nothing for me to respond to other than to say this. As we make clear in our submissions, the basis, as the Court of Appeal found, the basis for the intermediate approach is not only artificial, it's based on a misunderstanding of what Mr. Justice Ousley said, which we just went to. So, my Lord, I was going to then turn to issue 2, the question of approach, some of which I've flagged up and anticipated already in what I've said. We say not only is there clearly an important distinction for legal purposes and in terms of practical consequences between interpretation and application of policy, but we say that there are broadly 3 stages involved in deciding whether any particular development plan policy is a relevant policy for the supply of housing. First of all, there has to be a correct understanding of the meaning of paragraph 49 of the framework. Secondly, there has to be a correct understanding of the development plan policies. Both of those two steps are matters of interpretation and therefore matters of law. You have to understand correctly the policies you're dealing with. The third stage is the application of the planning policy in paragraph 49 to the relevant development plan policies, and that is the stage to which issue 2 relates. Is that stage an issue of law, or is it an issue of application of policy? The answer to issue 2, for the reasons I've summarised briefly already, the answer to issue 1 affects the answer to issue 2. The Court of Appeal's judgment on this issue, issue 2, flows directly from what it said about the answer to issue 1. And if I just take your lordships to paragraph 45 of the Court of Appeal's judgment, that's page 275 of the core volume. Where Mr. Justice Limbom identifies that deals with this matter.
Paragraph?
Paragraph 45. Whether a particular policy of the plan, properly understood, is a relevant policy for the supply of housing in the sense we have described it, is not a question for the court. It is, as Mr. Justice Uzzi said in paragraph 48 of Barwood, a question for the decision maker. And that is because the Court of Appeal's interpretation is concerned with effect, and therefore a judgment. And I took your lordships earlier to paragraph 35. The centrality of the concept of effect is also identified in paragraph 33 and paragraph 38. And it's therefore, because the Court of Appeal's conclusion flowed from what it said in relation to issue 1, one needs to look at the 3 alternative approaches to interpretation to see what answer they produce. And on the Court of Appeal's wider interpretation, it's not clear, with respect, whether there is any dispute or not. Because as I understand the way that the appellants put their position in their written case, it seems to flow from their suggested answer to issue 1. It's not clear whether, if the Court of Appeal's approach to issue 1 is upheld, whether they take any issue with what flows from that in terms of issue 2. And so we say, in the absence of anything from the appellants on that point, we say that clearly, as the Court of Appeal said, the judgment about effect is the application of policy. It's a matter of judgment, not interpretation or law.
Thank you.
But on the narrow interpretation, and if while we have the Court of Appeal's judgment open, it's worth just going back to page 268 to remind ourselves in paragraph 21 of what the narrow interpretation is said to be. In the fourth line, in the narrow interpretation, the meaning given to the expression relevant policy supply of housing is limited to policies dealing only with the numbers and distribution of new housing, and excludes and so on. That would appear on its face to be not based on an assessment of effect, but on the correct categorisation of subject matter. Is the policy dealing only with numbers and distribution of new housing? On the face of it, that would appear to be a matter of interpretation, and therefore not something calling for planning judgment, and therefore a matter of law. On the intermediate interpretation, this is over the page in the Court of Appeal's judgment 269.
Yes.
Intermediate or compromise interpretation, some restrictive policies will qualify as relevant policy supply of housing, but others will not. The latter category is said to comprise, as described in Barwood, policies designed to protect specific areas or features such as gaps between settlements, the particular character of villages or a specific landscape designation, all of which could sensibly exist regardless of the distribution and location of housing or other development. That, if I may say so, presents a rather mixed bag, and the contents of which will be varied and uncertain. There are some elements of categorisation and thus interpretation. Is this a policy designed to protect a specific area or feature? But there would also appear to be some elements of planning judgment. Is this a policy which could sensibly exist regardless of the distribution and location of housing and other development? The uncertainty as to quite what would be involved flows from the conceptual vagueness of the intermediate approach. But as I've indicated, my Lord, there are implications of the analysis of issue 2 for the analysis of issue 1. Not only the question of the floodgates of litigation, but also if one interpretation tends to leave no room for planning judgment on an issue of this sort, but the other does allow room for judgment, does allow room, that ought to tell in favour of the wider and more flexible interpretation.
You could argue the other way, that one is tolerably clear. Either it does or doesn't limit itself to the number of houses. There can't be much argument, whereas the other one, there may be a lot of argument about planning judgment.
Well, my Lord, argument about planning judgment.
Speculating as to how much argument there might be of what type seems to me to be a very questionable value in deciding what this phrase actually means.
Well, my Lord, no, with respect, that is not something that I could accept. For these reasons, in any individual determination, yes, the need to apply judgment is an important feature of the application of planning policy. That is recognised by the distinction that is drawn in the Tesco and Dundee case between approaching planning policy documents and how they're to be interpreted and approaching statutes or contracts. It is in the very nature of planning that there should be flexibility in the application of planning policy. The intermediate approach, as I have indicated, falls apart when detailed consideration is given to the question of how it might sensibly be made to work, and that suggests it's not a sensible or workable interpretation. And, my Lord, on that, I would just invite the Court to consider when questions arise as to whether something is truly a counterpart policy or whether it's some other form of restrictive policy, that is the intermediate interpretation. It's not the narrow interpretation, that's the intermediate interpretation. We say the Court of Appeal's approach is workable and sensible. It leaves room for the decision maker to exercise judgment and to reach appropriate decisions on a case-by-case basis.
Yeah, well, we have that. We have your submission.
I'm grateful, my Lord. My Lord, finally, so far as the source of power is concerned, we provided a note on that. What I would say, clearly I'll answer any questions that arise in relation to it, is that there is an important point of principle that is reflected in what we say at paragraph 11 as to the recognition by the higher courts of the essential role of the Secretary of State in having planning policy to secure coherent and consistent performance of administrative function. And we have directed attention at the top of page 4 of the note to a number of particular paragraphs of the judgment in Alconbury, which make that point. And I'd just like to ask your lordships to go to the supplementary bundle and to take up the decision in Alconbury, which
Tab
is
6, yep.
tab 6.
Yep.
And
You've given us the paragraphs.
I have indeed, my lord.
Which is the best one from your
My lord, if one goes to page, mine it's paginated, 117 at the bottom. It's
at the top?
At the top, 343.
Thank you so much.
Lord Clyde.
Right.
Paragraph 139, about halfway down that extract.
Yes.
There's where decisions are required in the planning process, not made by judges, by members of the administration. So it's dealing here with decision making. Over the page to 118.
Thank you.
4 lines down.
Yep.
Reference to what Lord Green said in the Johnson and Co Builders case. That decision must be an administrative decision because it is not to be based purely on the view that he forms of the objections vis-à-vis the desires of the local authority, is to be guided by his view as to the policy which in the circumstances he ought to pursue. Moreover, the decision requires to take into account not just the facts of the case, but very much wider issues of public interest, national priorities. Thus, the function of the Secretary of State as a decision maker in planning matters is not in the proper sense a judicial function. And then it goes on to say, planning and the development of land are matters which concern the community as a whole, not only the locality where the particular case arises. They involve wider social and economic interest, considerations which are properly to be subject to a central supervision. Lord, that's simply to provide the reference to the point I made earlier to your lordship.
Yes, I see.
In relation to the national being the collection of the local interest. Now, my lord, those are submissions that I proposed to make. I'm conscious that you may have questions. You may have questions on the note we put in on the source of the power. So if I can assist with any of those, I'm happy to do so.
That's very good of you, Mr. Philpott. Thank you. Anything? Thank you very much indeed.
I'm grateful, my lord.
Thank
Those are my submissions.
Mr. Honey. Mr. Kingston.
My lords, we've covered, in the context of deciding what the word "for" means, quite a lot of ground. I produced a short written note of the reply. If your lordship would like the written note, I have it available.
Thank you.
And also, I have available the overarching principles document, and I have one additional authority, as if we haven't enough, is in the decorum case. I think also we said we would complete the statutory provisions in relation to the effect of the 2004 Act, and I hope Mr. Richards is going to magically appear with all of that material.
Thank you.
Thank you very much, Derek.
Thank you.
Yep.
It is Kim.
Yep.
Thank you.
You don't.
Actually, that's the call. Please. Thank you.
Ashley. The principles document is essentially a reduction to paper of what you were saying yesterday, is that right?
Yes, it's in fact
Thank you very much.
simply an extract from my speaking note, but I hope it's faithful in all respects to the submissions I made orally.
Yeah.
This as well?
Yes. Yes.
My Lord, we've got, I think, we ended up with 6 relatively short points. The first one I've titled Plans Subject to Review.
Yes.
And I've taken this point, in essence, because of a number of comments made in the course of argument, which tended to indicate that because a plan was saying that at some stage in the future there was a commitment to review it, that as at the point of adoption, it should be regarded as some way carrying less than full weight and in some way provisional.
Yes.
And so, my lords, the fact that a plan is subject to a commitment to review does not make it in any part of it provisional or defective. The local plan inspector's report in the case of the Suffolk plan shows the comprehensive nature of the exercise he undertook, and I draw attention particularly to paragraphs 47, 50 and especially 51. Do your lordships have now the full version of the local plan inspector's report? I'm afraid I'm not sure whether it was handed in or not. Well, perhaps these paragraphs are in the extract that you have got, and I can make sure before I finish that you've got the full version, because you will need it.
Even if we don't have it before you finish, we can have it afterwards. Yep.
Thank you.
Okay, thank you.
Can you confine that e-form, lest everyone...
Yes, of course. Yes, of course. So the paragraphs that I'm particularly drawing attention to are paragraph 47, which is a paragraph that's been read to you, the inspector saying that he'd considered whether the examination should be suspended. The council said that if that was so, that they would be likely to withdraw it. And I therefore, last sentence, I therefore considered whether this would be in the interests of achieving sustainable development and significantly boosting the supply of housing in the district. So, Inspector clearly saying that to adopt the plan, even though it's not containing at the stage of adoption all of the housing needed for the whole plan period, was still going to boost the supply of housing because, of course, it would allocate sites which would meet the early part of the plan period. And then paragraph 50, relevant policies for the supply of housing should not be considered up to date until the council has demonstrated a 5-year supply. However, in the absence of the core strategy, the council would be reliant on an old-style local plan adopted in 2006 with significant parts that are considerably older than that. It is a core planning principle of the framework that the planning should be genuinely plan-led. So what the inspector was looking to achieve by in effect allowing the plan to go to adoption was a process which should be genuinely plan-led, and plan-led through the policies of the plan that he was going to allow the council, because he has a binding recommendation power here, going to allow the council to adopt. And then paragraph 51, while the land currently identified in the strategic housing land availability assessment and elsewhere would be insufficient to meet objectively assessed needs for the plan period as a whole, there are still a substantial number of sites which potentially could come forward in the short to medium term and boost the land supply. If the proposal for review were to be accepted, planning applications for housing would be considered in the context of an up-to-date suite of local development management policies that are consistent with the framework, the core strategy settlement hierarchy, and the locational guidance in the strategic policies. That sentence is a critical one in paragraph 51, and critical particularly in the light of Mr. Lockhart-Munry's submissions. What the inspector was endorsing was not a plan that he regarded as out of date, not a plan that was to be regarded as useless from the point of view of the development management, old language, development control function, but which would be providing a critical role. Right. And the rest is there. My lords, may I just make the point about the totality of the report, and the reason I'm anxious that you should see it. It's immediately apparent, without having to read it page by page and line by line, that the inspector undertook a soundness review which embraced all of the plan. So he wasn't signing off some sort of edited version or defective version, but as paragraph 51 indicates, and then the totality of the document provides the evidence to support it, something which was intended to be full in all respects.
Understood.
So back to my paragraph 1A, the plan, that is adopted on the basis of meeting the statutory requirements in all respects, soundness among them. It carries full section 38(6) weight from the date of adoption. The reference to the NPPG is a reference to the National Planning Policy Guidance, a yet more acronym for us to wrestle with. And I've provided your lordships with what I hope you might regard as a mercifully short extract from it. And the reason I've done it is that this is the Secretary of State telling authorities to do exactly what Suffolk did, which was, if you can get a plan which will provide an up-to-date policy framework on the books, even if you have to commit to a review at a later stage, preferably within 5 years, you should do it. So important is it that that up-to-date policy framework should be there.
This is the document in black and blue.
Yes.
And the blue is links, presumably.
Yes.
Yep. Okay,
it
thank
needs
you.
no further read-through from my point of view.
Thank you very much.
It's tolerably clear, but it explains what's going on.
Thank you.
The very same thing, paragraph 1B, this is what lies behind the Secretary of State's letter, which you were given. Of the, we were told by Mr.
That the date is clear from the second page.
Yes, it is.
Yes, I know.
But
Thank you.
This letter of the 21st July 2015, and the paragraphs upon which not a great deal of emphasis was laid, but which are extraordinarily important in this context, paragraphs 1 and 3, my Lords, paragraph 1, each local planning authority should produce, engage so far as possible, government attaches great importance, getting up to date, supporting them as a priority. Paragraph 3, as inevitably a plan cannot exactly account for future circumstances, there is real value in getting a local plan in place at the soonest opportunity, even if it has some shortcomings which are not critical to the whole plan. We've acknowledged this in planning guidance by setting out local plans may be found sound, conditional upon a review in whole or part within 5 years of adoption. It's precisely the same point, and it supports our position, the importance which the Secretary of State is attaching to the development plan, the importance the statutory scheme attaches to it. So, my Lords, nothing further on that.
Thank you.
And with regard to the saving direction, letter of the 14th of February 2008, fourth paragraph, Secretary of State's assessment refers to PPS 12, the protocol. The extension of SAVE policies listed in this direction does not indicate Secretary of State would endorse these policies if presented to us as new. It's intended to ensure continuity. Key word to note here in the context of submissions made to you, continuity in the plan-led system and a stable planning framework locally. My Lords, the Secretary of State has the opportunity not to save policies if he thinks they're inconsistent with any current approach.
Yes.
The saving of them preserves their weight as part of the development plan. And that's important because Mr. Young's submissions were driving towards the point of saying, well, they may be saved, but really they're not to be relied on. This saving direction is emphasising the importance of continuity, stable planning, and in effect endorses the continuing relevance of the plan as a Section 38(6) consideration. The second point, the statutory scheme. The 2004 Act ushered in a new formal planning regime. My Lord Conworth said yesterday, well, it was a complete new regime that was being ushered in. Mr. Lockhart Mummery demurred from that, but it was, my Lords, a complete new machine. Structure plans were abolished, old-style plans were phased out with a drop-dead date 3 years after the coming into force of Section 38. The saving provisions, which your Lordships, I hope, have now got from Schedule 8 to save beyond that date. The legal effect of saving is, as I've said explicitly, to preserve older plans as statutory development plans, which would necessarily carry Section 38(6) weight. I've made the point the Secretary of State has the opportunity of not doing so. it does not lie in anyone's mouth to say that safe development plan policies do not carry full weight. I've given you the reference in Daventry. I don't ask you to turn it up, but I do specifically draw attention there. It's the point we made rather light-heartedly, that old does not mean out of date.
We have
but
that
it is
point,
extraordinarily important in this context, in the light particularly of Mr. Young's submissions. The aim to put in place a complete new system was complemented by the power to ensure continuity of development plan coverage by the saving provisions. The new style plans, with a new emphasis on the importance of the development plan in the statutory scheme, reinforce our submissions about the statutory scheme and its importance. The repealing provisions that I've referred to there, this is, in one sense, perhaps one of the less exciting things to have to be looking at, but the reason for producing them, and they're probably the last 4 pages of the document that we've put in, with the page number 6 in the top right-hand corner,
Yep.
and then 7 and 8.
Which documents this do?
This, my Lord, it's Planning and Compulsory Purchase Act 2004, Part 9, Miscellaneous and General, and it looks on the front like that, I hope. And it should have arrived just a few moments ago.
Oh.
And you go to page 6. The reason for producing this is to deal with Mr. Lockhart Mummery's submission that really the 2004 Act didn't change much.
Well,
It did.
I don't think I've acquired this document. Have you got a spare copy, man?
Yes.
Well, that I've lost.
Have. One is
Okay.
coming.
Thank you very much.
yep,
Yep.
yep.
So, if you'll forgive the characterisation, 2004, out with the old and in with the new.
Understood.
All, from my point of view, reinforcing the importance that was being is put in the statutory scheme on the development plan. The next matter that was new in 2004, inspectors' binding recommendations were introduced. That to increase the weight given to plans. A local planning authority can't adopt a plan without complying with the recommendations.
Okay.
The soundness test, section
that,
20, introduced statutory new approach. Requirements changed that with regard to consultation, statements of community involvement make their appearance in the way that I showed you in opening.
Right.
Next, third point, a challenge to the NPPF. My Lords, we do not challenge the lawfulness of the framework.
No.
What we challenge is the interpretation of it. And as you'll see from
Your point is essentially you're saying that if it's interpreted the way that's suggested against you, that's not lawful. And therefore we should favour a lawful interpretation.
Thank you. And may I just ask you to note, and if your Lordships will have gathered, I'm not over-impressed with the forensics in lots of situations, but it is important to see from my learned friend's note on behalf of the Secretary of State, paragraph 15, the point I've made in my paragraph 3A, one of the word that is missing from what's said in the Secretary of State's note,
Yep.
and which was included in what Lord Justice Laws said, was the word effectively or effective. Does not lie within the Secretary of State's remit. That word is important because
Understand.
it's not just form, it's substance. B, on the wide interpretation view, the lawfulness is questionable. It does not respect the spirit and intention of the statutory regime or the framework itself, and I give you the paragraphs. It's contrary to the assurances given to Parliament about how the framework would operate. It's also not consistent with the impact assessment. I didn't take your Lordships to this in opening, and I notice that my learned friends have not felt it necessary to refer to it. But it is important to see, this is the document that was produced and referred to in the Redhill decision, where again the Secretary of State was a party. I've given you the references, and you'll note that what the Secretary of State said about the countryside. and the framework ensuring that it was going to be protected is all there in the impact assessment, a document which was used in Red Hill as a part of the means by which one might properly construe the framework. 3C, on a narrow view, the approach is not top-down, but on a wide view it is, because locally shaped policies are replaced by generic policies in some instances, and it removes protection of the development plan from, for example, the countryside. The wide interpretation replaces the determination in accordance with the development plan with determination in accordance with the framework. 3D, the question is which interpretation is the best fit with the statutory framework, to borrow my Lord Newberg's expression, the constitutional proprieties, the NPPF as a whole and ministerial statements. The best fit, we respectfully submit, is the narrow interpretation. I've then, perhaps rather presumptuously, got a heading, the respondents' errors in submissions. Twice in the course of submissions, Mr. Lockhart Mummery said that the local planning authority must meet the assessed need. I quote, "The prime duty is to identify needs and meet them." That is not correct. There is a duty to identify the full, objectively assessed need, but then only meet it so far as is consistent with the policies in the framework. That is not development at all costs. What Mr. Lockhart Mummery described was development at all costs and would be an unsustainable approach. And then at 4B, we have not submitted that the respondents are promoting an at all costs approach, but the submission makes it seem that they are, and the wide approach looks like a sweeping away of a whole raft of locally generated and evidenced policies. Fifthly, my lords, the specific policy arguments. The Suffolk policy is SP 19 to 27, and you've got the local plan inspector's characterisation of them at paragraph 51 of his report. And I invite you to note the plan's description of them. I think you were taken to this this morning, but we might just note it, please, in the authorities bundle 4B and the MS page 2458.
Very well. Yes?
This is about spatial planning.
All right, we were taken to that, yeah.
4.01.
Yeah.
I won't read through the excitements of the bullet points, but your Lordship should note the extent to which it's concerned with, for example, second bullet point, the concept of place.
Yes.
Fourth bullet point, environment, social well-being, quality of life, and the rest unrolls from that. What these policies are about, we respectfully submit, is clear from that introduction to them. They're about the sorts of factors which are to do with, to borrow the Minister's expression, the vision. And that, of course, is something which we saw from the way the plan itself characterises them at the policy overview at MS 2553, where the sustainability aspects included SP 19 to 29 and housing included SP 2. So that submission is consistent with the way in which the plan itself characterises its policies. Policy SP 15 concerns expressly the protection of historic parks and gardens. The inspector, as you can see from paragraph 21 of his decision letter, found a conflict with it, and he'd earlier found that it was up to date in paragraph 8. Yet on the wider approach to construction, it would now deem to be a policy for the supply of housing, a policy which is to do with protection of effectively a heritage asset. And then finally, under this section 5, the council, and perhaps I should have said Cheshire East Council,
thank you,
frankly admits that among the welter of conflicting judicial authorities emerging over a period of time, see the Court of Appeal at paragraph 20, the council's position has not been consistent. Nor, it appears, has the Secretary of State's. My Lords will, I won't say enjoy, but you might find it informative to read William Davis.
Well, you will enjoy it anyway.
Yeah, I did. I confess.
Well, litigation the world over is full of ducking and weaving.
Ducking and weaving, my Lord, it is. And how refreshing it is to see that the Secretary of State will engage in the same
No,
sport.
but I mean, William Davis is a good example of the problem. There you had a perfectly consistent view of what it meant, but a particular counsel, because it was in the interest of his clients to do so, argues for a particular interpretation. The judge then has to deal with that in the facts of that case. That is then picked up in another case as though it had a sort of wider significance, and so you sort of build up this body of law until the Court of Appeal tries to come along and sort of pull it all together. But inevitably, the parties, the Secretary of State, everyone else has to sort of duck and weave with the flow. I mean, if that's
My Lords, I wouldn't have made really any more of it, or indeed anything of it, if I hadn't had the finger so robustly pointed at me in terms of inconsistency. And on behalf of at least one local authority, I say with very great respect that if a bench full of High Court judges can't agree about it, how is a luckless planning officer in the delights of Cheshire supposed to get to grips with it in any meaningful way? My Lords, I say no more about that at all.
Thank you.
And then sixth point, and not quite finally, because a few points are raised from Mr. Philpott's submissions after lunch, which I've not been able to sweep up in the note. Paragraphs 49 and 14. The plain and obvious purpose of paragraph 49, in conjunction with paragraph 14, is to provide the opportunity to lessen the weight which would be given to development plan policies. Otherwise, it frankly seems to have no purpose. The suggestion that footnote 9 reintroduces the development plan policies, and that seemed to come from Mr. Young, has never featured in any argument that we are aware of. The argument has always been that it introduces the framework's policies in their generic form, not that in a circular way it reintroduces the very same development plan policies to which less weight has been accorded. And if I could interpolate there, paragraph 14 is explicit, isn't it? That what you have regard to is not the reintroduction, because of what's referred to in footnote 9, of the development plan policies, but the policies in the framework.
Yes.
Specific policies in this framework.
yes, but it must also include the working out of those policies in the local plan.
Well, if you'll forgive me, only if the argument is to become entirely circular.
No, I mean, when you're talking about something like, as it mentions, the heritage assets, it's the local plan, you'll find those, the non-designated heritage assets explained. Local green widgets.
You may, but that's the very reason why, I suggest, in the first place, you wouldn't want to construe paragraph 49 broadly, because one ends up then not in anything like a virtuous circle, but in something like a vicious circle. Because on the one hand, you start off saying, well, on a wide interpretation, this is the policy for the supply of housing, and accordingly its weight is up for grabs, if you'll forgive the colloquialism. You go to paragraph 14, you then discover on the back of the footnote 9 that that's among the matters which are specified as examples there, and you're invited to reintroduce as a contraindication the policy to which you've previously been invited to accord less weight. It's nonsensical. And as to the suggestion made, if I may say so elegantly, of course, by Mr. Philpott, that somehow we invite by our submissions the opening of some floodgates of litigation. My Lords, the litigation on the narrow interpretation that would ensue as to whether a policy was for the supply of housing is as nothing compared to what arises on the Court of Appeal's approach, which is to invite a situation in which 1 week in one inquiry, because someone, if you'll forgive the expression, gets lucky in an answering cross-examination, a policy is a policy for the supply of housing, called the right evidence, got the right answer, and the next week, in another inquiry, a tougher witness and not such a comprehensive evidence review, and it's not a policy for the supply of housing.
I understand.
My Lords, in terms of consistency, clarity, local people, if you'll forgive the expression, local people understanding what's going on and what the development plan to which they're invited to assiduously contribute means, which is a nonsense, I respectfully submit. My Lords, that's all on my note. And as to the Secretary of State's submissions made by Mr. Philpott this afternoon, I think probably the only one I need to pick up separately is that we have edited in our written case the wording.
You've taken out the word supply of.
Well, only to make the point that I made in my submissions yesterday, that the words for the supply of are intended as words of limitation. That otherwise, the words don't mean anything. So we're not intending to edit, and I eschew any intention to edit it, but rather to attempt to reach a sensible conclusion as to what, as we say, are the words of limitation mean. My learned friend made some submissions about extraneous material and what should be taken into account. And he drew your attention to his written case at paragraphs 6, 7, and 8. Don't look at the extraneous material. But with due respect, you will see, if you go to paragraph 135 of the Secretary of State's written case, I'm afraid I haven't got an MS number for it.
Very well. Yes, that's all right.
202.
Sorry?
202.
202.
Yep, 135. We have it. Thank you.
Paragraph
Yes, we have
135.
it. Yep.
The very first thing you see here being relied on by the Secretary of
Yes.
State is a document which, in the Secretary of State's terms, would be a part of the archaeology. It is not possible in these circumstances to have the cake and eat it.
Yes,
One or other approach. And may I make it clear that I invite the court, though the inspector's report doesn't, from my point of view, do me any harm, and most certainly the Suffolk Coastal Inspector's report is positively helpful on my case. But I make it very clear that our submission is that TW logistics is the right approach. That is, in the context of the development plan, once it's adopted, one should not be required to go on a paper chase, foraging round to see what was in this or that draft, this or that report, see what was in the inspector's report, see what resolution there was from the council.
Yes.
Not the correct approach. And what's more, it's not consistent with the statutory scheme, which invites attention to the adopted development plan, not the welter of material that might have spanned years before its adoption. My Lords, unless there is any other matter, which, give me a moment. Oh, yes, I did say. Discretion.
Yes.
I cannot think that your Lordships need me to say anything about simplex and the proper approach. But the variety of wording...
But you're going to.
Well, with half an hour before 4 o'clock, I could spend at least half an hour on it. But no, in fact, I'm going to resist the temptation to read it out extensively. But could I simply invite you to look at the words and the test, which has been now in place for years, which, with all due respect, has not been accurately reflected in
Why
this.
don't you just tell us what it is, because we don't need to.
The test was, I find it impossible to say that the learned judge was entitled to come to the conclusion that the minister would necessarily have reached the same conclusion if he had not acted on the erroneous factor.
Yes.
Would necessarily have reached the same conclusion. Yes. And I should just make it clear that my
I
answer...
said we need to be sure that he would.
Yes. My answer to Lord Gill's question yesterday was that Mr. Boyland could, not would. If I'm wrong, my Lord, you'll tell me, I'm sure. But I said could.
Understand.
And I made the point that he could.
Not that he would, I understand.
And also, of course, that that would be a matter for his planning judgment. My Lords, thank you for your patience. Those are my submissions, unless I can help you further.
Thank you very much. Well, we're very grateful to all council for their oral submissions and for finishing well in time. We're also grateful to all those who were involved in preparing the written submissions, which we printed cases, which we found very helpful. We will consider this matter and let you know our decision in due course. Thank you.
My Lords, if I may, before the court rises, I understand today may have some consequences for at least one member of the court. And although it's not been my pleasure to have appeared before Lord Gill before, I wonder if I might, on behalf of the bar, say just one or two things to mark the occasion. When I looked to see what sort of career Lord Gill might have had, I found I became exhausted. Exhausted because as I looked through not only a distinguished legal career, writing books, editing and producing encyclopedias, reforming the Scottish civil justice system, to name but a few, it was an exhausting read, my lords. But it would be a mistake, it seems to me, to as it were, mistake the lawyer for the man. And so I looked beyond the lawyer and found that on one particular occasion, distinguished by the presence of Cardinal O'Brien, who said, there is no doubt that one of the biggest challenges facing Catholic lawyers in Scotland today is a challenge which has faced many people in different groups in society down the ages. How do you live and act out your professional lives whilst at the same time remaining true to the teachings and doctrine of the Church? And I can safely say, based on a much wider parameter than the law, that Lord Gill has managed to do that, for which we're all very grateful.
Thank you very much. Perhaps I could add something. Unusually for a Scottish advocate and an English barrister, in the 1980s, Mr. Brian Gill and I were in chambers together. Mr. Gill had developed an expertise in, among other areas, land law and valuation, such that his reputation had vaulted over the debatable land, and unlike Bonnie Prince Charlie, had reached London. So he was invited to become a tenant in my old chambers, which specialised in land law and valuation. English and Scottish land law principles are rather different, but English and Scottish land valuation principles are not. And as the English justices in this court have recently learnt, when it comes to rating law, judges south of Hadrian's Wall have a great deal to learn from those from the north. Although, of course, Mr. Gill remained in practice in Scotland, his association with my chambers during the 1980s made me realise just how impressive Scottish advocates could be. Thereafter, our careers developed in parallel, both of us ceasing to be advocate poachers, becoming judicial gamekeepers. Lord Gill quickly developed a reputation as a first-class judge. His judgments, or opinions, as I should call them, were models of authority, conciseness, and lucidity. Models, I should say, from which many other judges, including me, would often benefit. As I've observed before, it's a depressing experience to read a judgment which makes you lose the will to live. It's all the more depressing when you come to realise it's one of your own judgments. At any rate, as a result of his conspicuous judicial abilities, Lord Gill became successively Lord Justice Clerk and Lord President, and thus he and I became colleagues again in a somewhat different situation from that which had obtained previously. So long as the United Kingdom exists in its present form, it's very important for the rule of law that the Lord President and the Lord Chief Justices of England and Wales and of Northern Ireland and the President of the Supreme Court work closely together. With Lord Gill, for me, that was not only a duty, it was also pleasurable and instructive. As Lord President, he was plainly a man with an iron fist in a velvet glove. Fortunately for me, I've only been subjected to the velvet glove, or I think I have. Lord Gill is so clever that I suspect that one may even have been subject to the iron fist without realising it. In all events, he's an intelligent, amusing, and stimulating companion who wears his considerable and well-adjusted principles lightly but firmly. Since his retirement as Lord President, Lord Gill has from time to time sat in this court. Scotland's loss has been the United Kingdom's gain. Sadly, as he's about to reach his sell-by date, but I'm sure not his best before date. He will no longer be able to sit here, but will have to pursue his other interests. So the law's loss is music's gain. On behalf of this court, I would like to thank Lord Gill for his enormous and long-lasting contribution to the development of the law and to the rule of law in Scotland and the United Kingdom generally. And I wish him on behalf of the court a long and happy retirement.
I wonder if I may add a short personal tribute. I have known Brian as a good friend and colleague for almost 35 years. He has always been energetic, and as a young advocate I found him very approachable and willing to give advice when it was sought. And he has always had a marvellous utility to see the funny side of things. The President has mentioned his skill in writing opinions. His legal opinions at the bar were focused, succinct and elegant, and his judicial opinions have shown the same qualities. As well as conducting a very busy practice at the bar, he found time to write a PhD on the law of fraud. He also produced the leading textbook on the law of agricultural holdings, and he edited the loose leaf. He introduced and edited the loose leaf of the Scottish Planning Law Encyclopedia. While coping with his practice, he also took on the historic task of being keeper of the Advocates' Library. That's a very historic office which has had among its incumbents the philosopher David Hume, who in 1751 described it as an office from which I received little or no emolument, but which gave me command of a large library. Brian received no emolument, but he loved the job because of his love of learning, and he undoubtedly got his reward from the command of a great library. He is also a born reformer. While he loves the traditions of learning and the traditions of the Faculty of Advocates, he never let the Scots law refrain, "It's aye been done this way," be accepted as a justification for avoiding needed reforms. As chairman of the Scottish Law Commission, he shook up an institution which had become unfocused and inefficient, introducing a strategy and a management regime which enabled its members to concentrate on producing practical proposals of law reform for the government within an acceptable time frame. It was an interesting experience to be a part-time commissioner there at that time, because on occasion I had to engage in shuttle diplomacy between the rooms to keep the commission together as Brian drove through the reforms. His reforming zeal reached its zenith with the production of the Civil Courts Review, which is the most radical shake-up and modernisation of civil justice in Scotland for over a century. And at the same time, he reformed the appeal system, wiping out in a short term the serious backlog of criminal appeals. But it would not be fair to speak only of Brian as the lawyer. He has always had a wide cultural hinterland, particularly in the field of music. He has long had a love of choral music. He is a skilled organist and a composer, and as well as his many duties as a judge, he was chairman of the Royal Scottish Academy of Music and Drama in his spare time, such as it was. I join you in wishing Brian a very long, happy and fulfilling retirement, and I hope that his many cultural interests will keep him as engaged in the future as he has been to date.
President, this is a very significant day in my life. Although I've spent most of my legal life in Scotland, I'm very proud of my membership of the English Bar and of happy memories of the time that I spent in practice in Falcon Chambers with you as one of my colleagues. So I am grateful to Mr. Kingston for his very kind and thoughtful words, which I greatly appreciate. They mean more to me than I can say. As for your kind words, Mr. President, I'm deeply touched. Over the last 2 years, it has been a great pleasure and an honour to serve in this court under your leadership. And that pleasure was all the greater for the fact that you and I had known one another for so long. I thank also my good friend of many years, Lord Hodge, who was my colleague in so many cases over the years, many of them planning appeals, when he always kept me right. You can trust everything he says. And it is lovely that that long connection and friendship has ended up with both of us sitting in this court today. My 22 years as a judge have been an honour and a privilege, not least the last 2 years sitting in this court. And so I conclude by thanking all the members of the Supreme Court for the privilege of their friendship. Thank you.
On that bittersweet note, we will adjourn. Court's now adjourned.